Good afternoon. I'm Corinne Kirkendall, EVP of Compliance and Regulatory Affairs at Pastime. It's a pleasure to welcome you to session 2 of 3 of NIADA's compliance webinar series. I'd first like to thank the FTC for joining us last week. They had a lot of great insights. It was really nice of them to join us. Pastime is a proud sponsor of this 3 series. Compliance is incredibly important to us. We continue to actively support the industry through our work on compliance, advocacy efforts, and issues that impact the dealers. Please reach out to the Pastime sales team, not me, if you're interested in payment assurance devices or you want to learn more about the revolutionary technology that we have, our wireless device Encore. Lastly, I'm always happy to provide you with the best practices documents in regards to the best use of these technologies. So let's get on with it. Today's session, we're going to focus on the Fair Credit Reporting Act, FCRA, and Reg Z. I'm sure there'll be a lot more acronyms in here for you, and Patrick will be happy to go through all those. So these are 2 very critical areas that directly impact dealer operations, consumer disclosures, and financing practices. So thanks for joining us again. And Patrick, let's begin.
Well, thank you, Corinne, and thank you to Pastime for being a sponsor of these important webinars. And I want to thank everybody on today's call for logging in. It shows how important you take these types of matters. As Corinne noted, this is number 2 of a 3-part series. Last week, we talked about the safeguards rule with special guests from the FTC. And this week, we will be focusing on the Fair Credit Reporting Act and its implementing regulation, Reg D. So, Yenny, if we could have the slide deck projected, that would be great. All right, so here we go. Next slide, please. And once again, just want to thank our sponsors, Pastime, for their generous sponsorship of today's webinar. And next slide. Much like last week, because this is a consequential compliance matter, we're going to ask that any questions that you have, please just submit them in the chat function. We want to ensure that we're giving precise responses that are well thought out and researched so that anything we pass to you is grounded in logic and fact. So feel free to put those questions in the chat function, and we will make it a point to get those to you in short order. Regardless of whether or not you're the person asking the questions, we will ensure that the responses are provided to all participants today. So next question, pardon me, next slide. So the Fair Credit Reporting Act, it's been around a while. It was passed during the Nixon administration, so it's older than me by a few years, and it sat around for a while, and it was amended a couple of times over the decades. 2003, when the Fair and Accurate Credit Transaction Act was passed, some of the notable points for there was it created the red flags rule, which we'll talk about in a short while. And then, of course, the Dodd-Frank Wall Street Reform and Consumer Protection Act amended the FCRA in 2010 when it created the CFPB and gave the CFPB plenary supervisory authority over the FCRA. In a nutshell, it covers the entire credit ecosystem from collection to use to dissemination of all that information that falls within the credit reporting space. As I noted, the CFPB has primary rulemaking responsibilities for the FCRA. They also have a larger participant rule where they are able to directly supervise the big 3, which is TransUnion, Equifax, and Experian. And then the FTC also maintains dual enforcement authorities. They supervise a lot of the smaller credit reporting agencies and financial institutions and users of data, of course, auto dealers being among that constituency. It primarily applies to the credit reporting agencies, and you'll see that I use the abbreviation CRA. Sometimes you might see NCRA being used. NCRA is an abbreviation that the banking regulators typically use. And that's because there are a couple of other CRAs out in the Washington world. There's the Community Reinvestment Act, which is a fair lending law. And then there's the Congressional Review Act, which is an authority that Congress has where they're able to dismiss regulations. They have the ability to review regulations that are promulgated by agencies, and they have the authority to rescind those regulations through a resolution. So CRA is typically used, but I just felt like it was important to point out that if you ever see NCRA, that's just a way that the banking regulators are distinguishing between those two other laws to avoid any unnecessary confusion. It is implemented through Regulation B, which can be found at Title 12, the Code of Federal Regulations, Part 1022. And there's a lot of information out there, both through interpretive guidance from both the FTC and the CFPB if you're looking for additional information. But if you want to read Reg B itself, Part 22 of Title 12 of CFR is where you will find that. Okay, next slide, please. All right, so unless you are only selling cars for cash, chances are the FCRA applies to you. There's two major ways in which it applies for car dealers. If you're either a user of the information, which you're pulling people's credit histories to make informed credit fitness evaluations, you of course have duties, which we'll go over in a moment. And then there's furnishers, that if you're reporting payment data, for example, to the CRAs, you are a furnisher and you have significant accuracy and dispute obligations, which I'll go over in a short while. But of course, when it comes to car dealers, particularly those that are involved in in-house financing, both of these activity tests generally apply. So the obligations set forth through the statute and the implementing regulations are generally applicable to the smaller dealerships, such as the ones that are on today's call. Next slide, please. Okay, so let's start with permissible purposes for obtaining consumer reports. You do need a specific reason to do it. Obviously, people's credit reports are sacred cows. So there are a few scenarios through which it's permissible to pull somebody's credit history. The most obvious one is, of course, if somebody is applying for a line of credit, but there are other examples as well. You can use it for employment screening. It's used for insurance underwriting purposes, but primarily it's for a credit evaluation, at least as it pertains to you all. Before pulling a report, there are a few things that you need to certify to ensure that it is legitimate. That is, of course, making sure that it is an actual credit transaction involving the person for whom that credit report applies. So this is to avoid unnecessary pulls of people's credit reports that could inadvertently draw their credit score downward. And then, of course, you need to make sure that that request is tied to an actual application to avoid unnecessary draws of the people's credit histories, which could create an actionable an actionable offense that could be used against you both civilly and regulatorily. So important to make sure that before you do pull somebody's credit report, that you do have a permissible purpose to do so. Okay, next slide, please. Adverse action notices. So if you take an adverse action, either in whole or in part of what's found in somebody's credit report, you need to provide an adverse action. You need to provide a rationale to the consumer for what that action entails. Some common scenarios would be the most obvious one. If you decline their credit application because their credit fitness just doesn't meet the appropriate appetite, that would be one particular one. Or if you are offering them credit, but you're doing so for terms that are less favorable than they had expected, you have an obligation to make that information known to them. That could be the credit, the APR that you're offering is a higher rate than was expected, or you're requiring a larger down payment. You just have an obligation to tell that consumer. The most common type, of course, is a denial of credit, and you just have to make sure that that information is shared in a fulsome and comprehensive way to ensure that they understand why the decision was made and what the terms were used to make that calculated decision. And of course, if you're not able to arrange financing at all after the application has been submitted, that constitutes an adverse action notice as well. Next slide, please. Excuse me, it's fairly prescriptive in terms of what you need to include in the notifications. Although your civil liability isn't as bad as it is on a regulatory aspect, you still need to make sure that you're covering all four corners of what's required under the statute and the implementing regulation. So I'm not going to read all of this to you, but a lot of it's fairly obvious to you as practitioners. It's the main information that was supplied as part of the application. Which CRA, whether it was TransUnion, Equifax, or Experian, that was used to not make that credit decision. And of course, consumers have a right to retain a copy of that report within 60 days. So a clock starts at the moment that the adverse action has been made, and the clock goes for 60 days for them to make that request. And most importantly, if the consumer is under the impression that the adverse action notification is erroneous and it's based on information that they believe should not be on their credit report, and the basis for your decision is that particular erroneous information, they have a right to dispute that information. And we'll go over dispute resolution in a short while, but this part I'd have to say is the most voluminous obligation that dealers have, because a lot of the complaints that go, whether it's to the FTC, the CAPB, or to the CRAs themselves, is based on people complaining about trade lines that are on their credit reports that they believe are erroneous and they want scrubbed clean. I just want to end this particular part by noting that you really do need to take that serious. It is a common FCRA violation for car dealers to fail to follow through with disputes that are submitted. So I just want to underscore the importance and the gravity of this particular provision of the regulation and the statute. Okay, next slide, please. So another obligation that dealers have is the risk-based pricing notifications. Now, this is grounded in the implementing regulation, and consumers have a right to be notified if the credit that's being extended to them is on terms that are, as the regulation puts it, materially worse than other consumers based on their credit report. And let me just note that you have options when it comes to making those notifications. You'll see it has to be clear and conspicuous. That is a term of art that is used in the regulation, but the regulation also extends a certain degree of latitude. It can be done written, orally, or electronically. Personally, I think a best practice is a belt and suspenders approach. Offered orally, that gives them an opportunity to ask questions about the what, where, when, and why. And frankly, following up with written notification is good best practice, because now you've created a paper trail that you can refer back to if you are ever audited, or if one of the regulators darkens your doorway, whether it's at the state or the federal level. You have that paper trail that you can justify and prove that you did explain to the consumer why their credit extension was on a different level than what they had expected. The consent, it must contain certain consent information, that the decision was made based on what was contemplated on the person's credit report. You should disclose what that score is if it's applicable. In most cases, it will be. And then any of the factors that were used that had that material adverse effect on the decision-making process. And then the most important part really is timeliness. You should make the notification before you bind that contract, but after the decision has been communicated. So right in that middle part there, and it gives them the opportunity to either proceed or to walk away. Next slide, please. Okay, as I mentioned at the outset, FACTA created the red flags rule, and quite frankly, we could do an entire webinar just on the red flags rule, which we may, frankly, as this program continues to get off the ground. But as we live in this digital environment, much like last week when we talked about the safeguards rule, which was about data security, the red flags rule is its cousin, and this is about ID theft. And whenever you're dealing with proprietary information, personally identifiable information, and the type of low-hanging information fruit that pernicious actors are likely to be going after, you need to make sure that the rule that you are complying with the red flags rule to ensure that you have a good ironclad ID theft prevention program that is not only on your shelf, but is updated regularly. Some of the things that the program must include is ways in which You can identify these red flags that are happening within your dealership that would be indicative of ID theft. Each dealership is going to be different than the next based on where you're located, the types of consumers that frequently come to your dealership. So you need to be thoughtful about what your program looks like, based largely on your footprint and the types of communities that you serve. You need to make sure that the people that are in your F&I operation, and frankly anybody that is communicating with consumers, quite frankly, is trained and knows how to identify these types of red flags that happen within the dealership's regular operations. Make sure that you have a good rapid response program in place and built into your program, so that if you do identify suspected identity theft, you have a response program that is ready to go, and anybody that would be responsible for operationalizing it knows exactly what the provisions of that rapid response program is, and they're ready to move out accordingly. And then really, as I mentioned earlier, yes, you have to have the program, but you need to make sure that it's updated. If you have if you are compromised and there is an ID theft within your dealership, that's a good reason to take a hard look at your program and see if any changes need to be made. This, again, it's going to be one of those programs that the regulators will ask for the moment they walk into your dealership, or they send a request for information ahead of any type of an exam or any type of investigation, based on actionable activity that they're seeing, whether it's through their consumer complaint database or other regulatory measures that would prompt them to come over and take a look at your books. Next slide, please. So these are some of the kind of examples of red flags that you would normally see in a dealership. The most obvious one, if somebody has already stolen an ID and they're attempting to use that to buy a car from you, they're probably going to have ID documents that look suspicious. So just be very mindful of that, whether they look like they have been forged, or they've been replicated, or they've been photocopied. They're just not original text. If they have credit reports or fraud warnings on their credit, on the credit report that you pull, that could be indicative of a person who has stolen somebody's identity and is attempting to pass themselves off as the person who has put those very same fraud warnings on their credit report. So, and we'll get into report alerts in a moment, but that's also the type of a red flag that you should be looking for. And then, of course, if they are presenting information that is in conflict with one another, if the social security number on one document doesn't match up with the social security number on their identification, or likewise with their addresses or any other type of information, if they don't comport, they don't line up, these are just red flags that you should be mindful of. Don't take them lightly. They are typical scenarios of an attempt to steal somebody's ID. And then, of course, suspicious financing behavior. And there's a whole host of these that we could go over. A couple of examples that I'll just toss to you would be, if you seem to think that somebody may be running a straw buyers scenario, where they are, there could be people below the border that are using people above the border to purchase cars using illicit funds, and those cars then will be transported back below the border and sold on the black market. Or if they're using shell corporations, if you will, that don't disclose the beneficial owner of the line of credit, that's also indicative of illicit financing and the types of suspicious activity and behavior that you should be on the lookout for as part of a good red flags compliance program. And most importantly, much like the safeguards rule, the ID theft program should be approved either by senior management or, depending on your size, your board of directors. Before I move on from this, I just want to note that if you're attending the convention in June, and I really hope that you are, we're actually going to have a class specifically on synthetic ID theft in dealerships. It's going to be taught by the Chief Risk Officer for Capital One Auto. Synthetic ID fraud is becoming more and more sophisticated. It's on the rise. And so therefore, we've decided to dedicate one of the 50 plus hours of education that we have for the convention just on this particular topic, because that's how important it is. And the consequences of not knowing what to look for and failing to comply are easily avoidable if you pay attention and you do the right thing and you build out a program that is really grounded in all the types of things that I'm talking about and Evan Baker from Capital One will talk about in June. Okay, next slide, please. So this one goes without saying, but I'm going to talk about it anyway. If you are collecting information pursuant to your credit decision-making process, you need to ensure that you have proper and responsible disposal procedures on place. Why? Because we want to make sure that this information does not get out in the wind, which creates ID theft opportunities, and then we're right back to the red flags rule. So the regulation itself gives you options. If you maintain paper copies of this information, you can strike a match, you can pour bleach on it, you can shred it, you can turn it into pulp. Choice is yours. You just need to ensure that that information has been completely destroyed to a point where it cannot be used in a way that the information can then be reverse engineered, if you were, or cobbled together in order to gather information that could be used to steal someone's identity. Most of you are likely keeping it electronically. We are in the 21st century. So if that is the case for you, you need to ensure that that information has been irretrievably destroyed, taken away and removed from your files to eliminate any opportunities for people to take that information and reconstruct it and use it to steal people's IDs. The types of information is the type of information that you're collecting as part of the credit determination process, but it's the credit reports and the application. Obviously, the application includes a lot of PII, and then any ancillary financing documentation that contains this type of information. All of that is within the universe of information that needs to be properly and responsibly disposed of as part of compliance with FCRA. It goes without saying as well that sloppiness in this particular space has been and will continue to be the rationale and the basis for avoidable enforcement actions by the regulators at both the federal and the state level. So don't take this lightly. Don't leave the cabinets unlocked. Don't allow people who don't have a need to know to have access to this type of information. And obviously don't keep it unless you have a need and a qualified business purpose to keep it. Okay, next slide, please. So fraud alerts and active duty alerts. This is actually a lived experience for me because my wife's ID was stolen back in 2016. And in the space of a weekend, somebody took out 5 credit cards and furnished their home and bought all new appliances before we realized it, because we didn't realize it until the credit card bills got in the mail. So what did we do? We put fraud alerts on our credit reports. So whenever we go to, let's say, buy a car, there is that extra step that is taken where we have to verify with the salesman that we are who we claim we are. And I know it's an extra step and it can be burdensome, but it is a right that consumers have. And it's one that they tend to exercise regularly, particularly people with large credit credit scores or are frequent consumers of lines of credit. So if you do get if you do get some type of a fraud alert, just recognize that that's usually a safeguard that's been put in place by the consumer to ensure that nobody is using their credit score in a way that is impermissible. And then, of course, there are active duty alerts. And under FCRA, active duty service members, they can place up to a 12-month active duty alert when they've been deployed. That's really meant to give them the ability to safeguard their identity while they are deployed. And when you do get an active duty alert, a lot like a fraud alert, you need to ensure that you are taking the appropriate steps to confirm that the person is who they claim to be. And it's just that extra choke point that's been put in place to make sure that somebody is not passing themselves off as someone who they are not. Next slide, please. Okay, now this is the grandfather of them all, which is dispute resolutions. And I can tell you in a past life, I used to bathe in these types of things because they would be, a lot of people would dispute trade lines that were on their credit reports. And I would see them all the time. And the regulators take this very seriously. The CRAs take it very seriously. But you will have an obligation under FICRA to investigate any type of a dispute that a consumer makes. Once that dispute has been received from a CRA, you have to conduct an investigation that is reasonable in nature. You need to look into the facts and circumstances and check to see if the dispute is legitimate or illegitimate. And part of that is looking at the various ecosystem of information that would be relevant, whether it's your records, the payment histories, any information that bound the contract, anything that could help to justify whether it is an actual appropriate line on their credit history or an inappropriate one, because you need to make sure that it's justified appropriately. And if it is accurate, great, you make it clear that it is. But either way, that the results need to be reported back to the CRA in question. And if you do identify information that is inaccurate or erroneous, you have an obligation to correct or delete that information. And again, I'm going to continue to beat this drum. Failure to do so will put you on the wrong end of the regulator. So make sure that you follow through with this in an accurate and a timely manner. Excuse me. Next slide, please. Okay, just some of the contours of what's required under dispute resolutions. And again, I want to note one other thing, which is this is by far the biggest complaint that beyond what the CRAs get, the CFPB, out of all of the complaints that they get, I'd have to say that credit disputes are by far the biggest one. In fact, it's been in the news recently about they're getting more and more. And because the CFPB isn't what it was a couple of years ago, they're really starting to pile up. And what that is going to mean to me is that the CRAs are going to start to get anxious. So taking this very seriously is more important than ever. You generally have 30 days after you receipt of that dispute to conduct the investigation. However, based on the complexity of the dispute or the inability to make an informed determination, you can get that extended by an additional 15 days. That just extension needs to be sought appropriately. And then again, the results of the dispute, they need to be met and sent to the CRA so that the CRAs can update the trade lines on the consumer's credit report to ensure accuracy, and anything that was reported in an inaccurate way has been changed accordingly. Next slide, please. Okay, so if information is incorrect, and you make a determination that the information is inaccurate or incomplete, obviously you need to correct it, which we already went over. You need to notify whichever CRA is in question that the correction has been made. And then all of that corrected information is sent to the CRAs that receive that data to make sure that you have continuity across that waterfront, to ensure that if there's been a change that needs to be made, it's being made appropriately across all three. If you can't verify it, then you have to delete the disputed information. In this case, the consumer wins. And if you don't correct those inaccuracies, I just want to underscore this, the enforcement liability is significant and it's extreme. And it really is an avoidable misstep in your compliance obligation. So please make sure that you take these types of responsibilities very seriously and timely based on what's required. Next slide, please. So this is an area that I know that we see in the buy here, pay here space. It's getting more and more popular in various areas that extend credit, which is reporting positive payment information to the credit reporting agencies. You may have seen or heard that there's a real push to have things like rental payments or utility bills reported to the CRAs as a way to build people with otherwise thin credit histories the opportunity to build that credit score up to a higher level. And I know some folks in the used car space also advertise and that they report positive payments to encourage that behavior, and also to help your customers build and strengthen their credit profiles. The only thing I want to leave you with here is, if you promote, whether it's on your website or any other advertisement or promotional information, that you report positive, timely payment information to the CRAs, it is critical that you follow through on that practice. In addition to it being false advertisement, failing to do so can and has been the basis for enforcement actions by both the CFPB and the FTC. It's the type of information and paper trail that they will look at if you're being investigated. So while this is voluntary, if you opt to do so, please follow through with it appropriately and thoroughly so that you are not found to be out of compliance with something that you were doing on a voluntary basis to begin with. Next slide, please. So now I'm just going to go over some practical steps to keep you in compliance. You know, we talked about the red flags, having that program in place. That, of course, is an important one. Make sure that the ID theft program is not only on your shelf, but it's updated on a regular basis. Just having a global FCRA Reg V compliance policy is important so that anybody who's touching consumers' information recognizes the start points and the end points and what permissible uses are, and anything that could affect a credit decision. Just make sure it's grounded in a policy, and make sure that people that have a need to know are aware of where the policy is kept. And part of making sure they know where that policy is kept is conducting regular employee training. Just employee training for FCRA and all of the other consumer finance laws that you're responsible for complying with. It's important. It's good hygiene. It keeps your regulators off your back, but it also makes sure that people understand what their specific obligations are based on where they fit within your dealership. And of course, as we mentioned earlier, make sure you have a good, timely system for addressing disputes. People will dispute even if the dispute is not a real dispute. They can do so because they recognize that they can, and you have to go through the process of investigating. But whether it is a legitimate dispute or a dispute that's fairly tenuous, you still have that obligation to address it based on what's required under the law that we talked about earlier. I just want to reiterate how important it is to make sure that you follow through on that. It's one of those very, very easily avoidable areas where you can find yourself out of compliance. All right, next slide, please. Common compliance gaps. The top one should be pretty obvious and self-evident. You need to have a legitimate, permissible reason to pull somebody's credit report. We talked about that at the top, and I just want to underscore it. Failing to send any of the required notices that I went over earlier. Not having good ID theft processes in place that comport with your obligations under the red flags rule. Again, ID theft is on the rise. It's getting more and more sophisticated. Making sure that you take it seriously is important. Not only is it important to make sure that you stay in compliance, but frankly, there's brand and reputational consequences. You don't want to be the dealership that is in the news for being responsible for either a singular or a wholesale ID theft operation. And criminal actors are looking for those paths of least resistance. They're looking for those areas of commerce that may have easy doors to walk through. They work quickly and they work cleverly. Just don't fall victim to that. And that really is grounded in making sure that you're appropriately and thoroughly training your employees on all avenues of what's required under FCRA. But of course, as we talked about earlier, appropriate safe handling of the information, appropriate storing of the information, and of course, responsible destruction of that information when it's no longer applicable for your day-to-day activities. And once again, if you do report that positive payment information to the CRAs, make sure you follow through on it. That has been an area that has been the subject of enforcement actions, and let's do everything that we can to avoid that from being the case moving into the future. dispute resolution, ensure that you have an appropriate one on the books that's thought out, that's based on your business plan. And then again, once the employee training is critical, you should do it at least annually. But if you have some type of an action forcing event in your dealership, whether it is a cyber attack or an ID theft ring or some type of a remedial action that has been sent to you by your regulators, that's a good reason to do a refresher training for your staff. One, to identify where the breakdown is, and two, to take appropriate steps to correct it moving forward. Okay, next slide, please. So I know this is a parade of horribles and a parade of scaries, but just to be perfectly clear, there are significant consequences for failing to comply with everything that I've talked about here. The CFPB and the FTC can, have, and will continue to take enforcement actions out against you for failing to comply. State attorneys general can take out enforcement actions. There are private rights of action. In other words, your consumers can sue you civilly through both individual lawsuits and class action lawsuits. And then something that's not up here, but I think it's important to note, is Section 1041 of Dodd-Frank allows state regulators to enforce federal consumer protection law. All of the consumer protection laws that are enumerated in Dodd-Frank, it's about 13, they have the right to enforce that at the federal level. And the FCRA, of course, is one of those. And as I noted, you can have statutory damages, you can have punitive damages, and you can be on the hook to pay the attorney's fees. One thing that we're working on here in Washington, and I want to qualify this by saying that legislation moves like lava. It's difficult to get things to pass, but that's never a reason not to try to get something to pass. We are pushing tort reform legislation that would harmonize FCRA with the other federal consumer financial protection laws. Just bring some common sense tort reform that would bring FCRA in line with the other consumer financial protection laws that carry civil liability. There's a disparity between FCRA, TILA, or ECOA, and what this legislation would do is bring them on par. It would limit attorney's fees, it would eliminate punitive damages, and it would limit class action lawsuits. I'm just letting you know that that's something that we're pushing for here in Washington to try and bring a little bit of parity. It's not likely to move anytime soon, but that's not a reason why we won't continue to zealously advocate for it, because it's good for your businesses, it's good for the auto industry writ large, and frankly, it's time to bring some parity across the entire waterfront of the rules and regulations that are required to comply with. We need to have some consistency. If something applies to TILA, it should apply to FCRA when it comes to your liability and your culpability. Let's see, next slide. That brings us to the end. I just want to end by noting that nothing that's been discussed today should be construed as legal advice. If anything that I talked about triggered something with you in terms of what your compliance program looks like, and you feel as though you need to consult a legal professional, I encourage you to do so. If you need a referral, I am happy to make that referral. Just reach out to me. That's my email address there. I'm happy to put you in touch with a lawyer that is barred in your state, or a compliance professional with whom we work regularly to provide further guidance. But we will make an archive version of this webcast available to you all, so you can share it with your coworkers and your teams. And we will also make the deck available. And as far as the question is concerned, if we received questions in the chat, as I noted, I will go through those questions methodically and thoroughly and provide responses to everybody, regardless of whether that question was asked by you or not. So that concludes today's webinar. We've got our third one on the 5th of May. That's going to be on the Equal Credit Opportunity Act. Looking forward to that one as well. And thank you all for tuning in. It's a pleasure talking to you. It's a pleasure representing you in Washington. And thank you for your interest. And I look forward to seeing some of you, if not all of you, this time next week. So enjoy the rest of your day. And thanks very much for your interest in this. This is important to us. Thank you.